So, the hazard would come from one of our products, and that would be the vegan leather cases, due to them being made of polyvinyl chloride, or PVC. This can be a potential risk for such cases because PVC is a very toxic material to use for vegan leather. This is because during the creation process of vegan leather made of PVC, it releases harmful toxins into the air. The tort that is committed in this hazard is called negligence. Negligence is when a business or individual causes harm to others unintentionally because of their carelessness.
The tort that is identified is negligence, and the fourth part are given below. Duty of care. The plaintiff should show the defendant owned her lawful obligation of care considering her current situation. The obligation of care can emerge from various variables like connection between the plaintiff and the defendant, client, supplier, anybody who encounter their item, product. Organization have an obligation to ensure that items don't cause harm to anyone. Second, breaching standard of care. This depicts that what is going on when the defendant neglects to meet the obligation of care by acting or neglecting to act in the necessary manner to decide whether somebody breaching their obligation of care, a court will utilize them. The reasonable member standard, which depends on how a typical individual would mindfully act experiencing the same thing. If an individual would have acted diversely in the situation to try not to cause harm, then at the point the defendant will found to have breached their duty of care. Third, causation. It is additionally important to show that the defendant breach of duty of care really caused the plaintiff harm. The two kinds of causations are genuine cause and proximate cause. Cause as a matter of fact depending on whether it could have been foreseen, genuine cause of the wounds. This can be laid out by utilizing, but for the test, all in all causation is laid out by assuming isn't shown that. However, for the activities of the defendant, the injury not have happened. Proximately cause is more complex. Proximately cause depends on whether the defendant might have sensibly predicted that their activity could cause a physical issue. All in all, the defendant ought to have sensibly guessed that her lead could bring about something being harmed. Defendants are usually not liable for injuries that were unpredictable or could not be result of their conflict. Fourth, damages. This really means there was some mishap or harm caused by the defendant breach of norm of care that a court can remunerate the plaintiff for as a rule of honor of cash. In this case, the manufacturer duty to provide the customer with all the information on hazards of using PVC material in vegan leather. Here the client has the right to know that PVC can be found in composition of some vegan leather. PVC releases dioxins which are potentially dangerous in confined spaces and especially dangerous if burnt. For example, in case of taking reasonable care to avoid act or omission which could reasonably be expected to injure the client would be considerably duty of care. Second, on the other hand, there is no ground for a claim unless the party owes a duty of care breach in some way. Here, if the manufacturer or defendant like there must be a relationship of proximity in which the failure to take a responsible care might foresee cause loss or harm to the plaintiff customer. For example, in the case of a new batch of phone cases just came from the factory and is yet to be labeled with caution label that consists material before bringing out on the display is now placed near the counter and customer pick one up and scan the counter for self checkout. Third, following which will be determine causation. The reasonable foreseeability inquiry is objective and it must be undertaken that the standpoint of reasonable person whether their defendant manufacturer actually foresaw the risk which ultimately manifested in injury to the plaintiff customer if not determinative. Reasonable foreseeability represents a low threshold and is usually quite easy to overcome. A plaintiff must merely provide evidence to persuade the court that the risk of type of damages that occurred was reasonably foreseeable to the class of plaintiff that was damaged in the case. It would be reasonably foreseeable that the customer suffer health issues as a consequence of manufacturing negligence in the locking, securing, storing, and unlabeled products. It could be considered that the risk of injury was reasonably foreseeable. Fourth, if there was actual harm or injuries caused by manufacturer's fault, like in the case of customer get chronically ill with asthma, cancer, or any other life-altering disease, the breach of norm by defendant is identified, will have compensated to the client or the trial judge finding the reasonably foreseeable physical injury sufficient to bring the circumstances of this case within a category of relationship which has already been found to support duty of care.
In order for such cases to minimize the risk of this hazard is to use polyurethane instead of PVC for their vegan leather cases. Polyurethane is a type of polymer. Polyurethane would be a better material choice because it can be made of sustainable materials and can be reused and recycled. This hazard could have been avoided if the owner decided to use polyurethane. But the problem with using polyurethane instead of PVC is the cost of it. Such cases is still a small business with not a lot of customers, so it's hard for them to gain profit and revenue. The plan for the owner was to use PVC until they start making profit and revenue, then to switch from PVC to polyurethane. He knew how toxic PVC is for the environment, but still proceeded to use it because he wanted to cheap out on his customers.